This half-hour training is a basic primer for pro bono attorneys and law students working with survivors of intimate partner violence. Over the next half hour, we will review the basic ethical framework of working with a survivor of intimate partner violence, introduce the dynamics of intimate partner violence, model some interviewing techniques in the context of a mock interview, and suggest some concrete best practices. Intimate partner violence or domestic violence is a pattern of behavior that is used by one partner to gain or maintain power and control over another intimate partner. An abuser's goal is to create a fixed imbalance of power. Domestic violence occurs in every country and neighborhood among people of all races, cultures, sexual orientations, gender identities, religions, and income levels. In the United States, 1 in 4 women experience abuse during their lifetimes. It is important that lawyers are able to identify all of the ways in which an individual client has been subjected or is being subjected to intimate partner violence. Physical and sexual assaults are the most apparent form of violence, but may not be present in all cases. The power and control wheels developed by the domestic abuse intervention programs are a useful visual tool to describe the most common abusive behaviors and tactics. Physical violence is often used to instill fear in a target of abuse, but there are other insidious forms of abuse that exert power and control over a target. For example, preventing someone from getting or keeping a job, making her ask for money, taking money from her, and not letting her have access to family resources. Many abusers will make light of the abuse. They will tell the target that she is crazy and deny that the abuse happened, or they will blame her for the abuse, saying that she was the one who caused it or she deserved it. Some survivors come to believe these statements. Another powerful tool of abuse is emotional and verbal abuse. Abusers often insult victims and put them down, saying things like, "You're worthless," or "You're nothing without me." Many abusers also socially isolate their targets by controlling who they see and talk to, monitoring their whereabouts, and putting limits on their contacts with people outside the home. Sometimes abusers use jealousy or false accusations of infidelity to justify these actions. Survivors of intimate partner violence are a unique client population because their legal concerns are often embedded in very personal, private matters. Effective representation requires that the lawyer earn the trust of a client who has experienced abuse. There are a variety of ways in which trauma manifests itself after an experience of abuse, and response to trauma varies from person to person and depends on the nature, severity, timing of the trauma, and exposure to previous incidents of trauma. It is not uncommon for clients to withhold crucial information from lawyers out of self-doubt, shame, fear, or disapproval, have difficulty processing or remembering information due to experiences of trauma, remember certain incidents or moments of assault vividly but not others, and not remember the incidents or moments in sequential order, present as excessively hostile or difficult, or in contrast, be surprisingly flat in their affect, minimize the severity of the abuse, or exhibit signs of mental health conditions such as post-traumatic stress disorder, depression, and disassociation. All practicing attorneys are ethically bound to have competent knowledge of the applicable law before representing any client in any type of legal matter. Beyond the duty to have competent knowledge of the law, a lawyer representing a survivor of intimate partner violence should be equipped with competent knowledge of the dynamics of intimate partner violence. The American Bar Association's Commission on Domestic Violence published a document titled Standards of Practice for Lawyers Representing Victims of Domestic Violence, Sexual Assault, and Stalking in Civil Protection Order Cases in 2007. The ABA Standards of Practice suggest that, quote, the lawyer should understand the potential risk of escalated violence due to litigation, and how the experience of domestic violence, sexual assault, and/or stalking may affect the client-lawyer relationship, including the process of establishing rapport with and gathering information, evidence, and case direction from the client. When you introduce yourself, don't assume the client is clear about your role. Instead, take the time to explain who you are and exactly what you're going to be assisting her with.
Good morning, Ms. Oliveira. My name is Anna Ognabeni. This is my colleague, Wendy Silva. Thanks so much for coming in today. So I figured we would just dive right in and let's start talking about your case. Why don't you tell us what's going on?
Sorry, so you're the DAs, right?
Oh, no, actually, you know what? That's a great reminder. Thank you for letting me know. We should introduce ourselves better. Both Wendy and I are law firm associates, summer associates with the law firm of Smith & Smith. And Smith & Smith has taken your custody and order of protection case from her justice. We're going to be representing you pro bono. That means for free. You won't owe us anything for your services, and we're going to try and help you out with your custody and order of protection situation. We're not criminal attorneys, so we're not going to be able to do anything about the criminal case against the father of your children. Does that all make sense?
So do you work for her justice?
We work for the law firm of Smith & Smith, but her justice has placed your case with us.
Oh, okay.
And if we have questions about your case, we can also consult with her justice about your case.
Explain attorney-client privilege. Discuss confidentiality in understandable terms, not legalese. This goes for all legal concepts you discuss with your client.
We're your attorneys, so once we sign the retainer today, we're going to be representing you, as I said, in your custody and order of protection case in family court. That means that everything that you say to us is going to be completely confidential. We're not going to tell anybody else about it. We might talk to her justice about it, like I said, but her justice is part of the confidentiality of your case. Now, in addition to being confidential, everything that you tell your attorney is privilege, and privilege means that if I'm subpoenaed to testify about anything that you've told me.
Sorry, what is, I don't understand what all of that means.
Okay, I'm getting a little bit too legalistic, I apologize. So basically what you need to know is that you can feel comfortable telling us anything that you want to, and if you don't want to tell us anything, that's okay too. Just so you know, the more that you tell us about your situation and the things that you want in this case, the better that we're going to be able to help you. But we're never going to have to tell anybody else anything that you tell us unless you tell us it's okay.
Explain that certain details may be hard to share, but that nothing will be disclosed without the client's permission.
It's so hard to talk about it, but I don't really want to revisit a lot of what happened, so unless we absolutely need to talk about it.
As I said at the beginning, everything you tell us is confidential. You can choose what you want to tell us and what you don't want to tell us, but as I said, the more that we know, the better that we're going to be able to help you, the better case we can put on for you. Just so you know, a custody case in family court, a lot depends on the behavior of both you and Simon. How much time has been spent with the child.
Nothing.
Domestic violence.
He's awful. He's awful. He doesn't spend any time with her. He was an awful husband to me. There's nothing there.
Mm-hmm. We need to tell the judge specifics. So if you can think of any specific examples about times that he's been awful.
If the client is reluctant to disclose details, explain why details are important to her case. Keep in mind the client may be concerned for her safety.
You mentioned that you wanted to keep your address confidential. Does he know where you're living?
No, and it has to stay that way. That's the one request I have. He cannot know where I'm living.
Reiterate confidentiality and validate the client's feelings.
For the address confidential, we can ask the judge to keep your address confidential so that he doesn't know. But there are times when the court might want to know where the child is living. So we can give that information to the court.
But he won't have access to it, right? He won't know
We would
where I'm
ask the
living.
court to keep your address confidential.
Okay.
While discussing traumatic incidents, support and validate your client. Avoid questions that put your client on the defensive.
And then I was given the order of protection.
That must have been really scary.
Yeah, it was awful.
Had you ever called the police before?
No.
You didn't think that you needed to call the police?
Let the client know when there are issues beyond the scope of your representation. Talk to your her justice mentor about any issues that you don't feel equipped to handle.
I was scared that if I called the police, I would get deported, and I have Sarita now, and I can't risk that. I can't risk, ruining her life. So that's why I never called the police.
Just so you know, we're not immigration attorneys, and so we can't specifically help you with your immigration case, but we can reassure you that participating in family court proceedings like this is not going to be the reason that you get deported. And so anything that you say in family court, it's not going to come back to bite you or to get you in trouble with immigration. If you need some referrals to talk to immigration attorneys, we can provide those at the end of this meeting.
Okay.
It is important to involve your client in case strategy. Discuss potential weaknesses in your client's case and brainstorm possible solutions with your client. Consistently validate your client's actions and feelings while identifying her strengths.
I want to talk more about the history in a minute, but I just want to make sure that we have all the details about that one day when he was arrested first, so that we can present the best possible case to the judge. So can you specifically tell us when he slapped you, where he slapped you?
He slapped me multiple times across the face and my chest, and my head.
Did he injure you?
Yeah, I had a headache for days after that.
Okay.
Did you have to go to the hospital?
I didn't go.
Why not?
I was scared.
Did you do anything to take care of yourself? Did you take any medication? Did you do anything?
No, I had to go to Sarita's event right after it was all over, so I didn't really do anything.
There's a chance that if your husband has an attorney, the attorney might try to spin that and say, oh, well, you couldn't have been that hurt because you just went right to Sarah's event. Sarita, I'm sorry. Can you give us something to say in response to that? Can you think of anything that we could say? We understand. I mean, you wanted to be there for your child. We just want to make sure that we're prepared to deal with any bad things that your husband's attorney might say about you.
I don't know. I couldn't go because I was very new to this country and didn't know how things worked. I was scared.
You wanted to be strong for your daughter too, maybe?
Yeah, I'm a mother. I can't. When you're a mother, you put yourself second, not first. And Sarita had an event, so I just had to go to her event.
When your client feels strongly about a particular result, manage her expectations by explaining how the court may perceive the situation. Avoid predicting or guaranteeing any particular outcome.
Well, there are some cases where the court understands that there's an order of protection, but they still allow the parent to see the child.
How? Why?
He's still the father.
So? But he hasn't been, technically, he doesn't provide for her. He creates stress in her life. She saw a lot of the abuse. How is that possible? How can a judge tell me that this is a father that should have the right to see their child?
Yeah, it's a really good question, but it's something that we do the best that we can to present the evidence and all the reasons why you believe that he shouldn't be seeing Sarita. But really what the court looks to is if there's an immediate danger that he's posing to Sarita, that is probably the only reason why they would not allow him. And that's a very hard thing to show. He has not been, from reading your court file and what you wrote, he has not been any danger to her. You have allowed him to see her in the past. And so that's something that you may want to, will help you to prepare for if the court decides that he gets to see her.
That's ridiculous. I can't believe that.
I understand that you're really frustrated. As attorneys, we're going to do our best. We're your attorneys. We're going to present the best possible case that you have. We're going to advocate for what you want. But we can't guarantee any particular results. And in the end, it's going to be up to the judge to decide. And we're going to do our best to help you, but we also want to make sure that you understand that you might not get everything you want out of this case.
Okay.
Reiterate confidentiality and validate the client's feelings.
I can tell this is frustrating for you, and I totally understand. If it were my child, I wouldn't want someone like that around my child either. And I know you have been through a lot with him and a lot of things he's done. I'm sure it's really confusing that we're telling you now that this person that's hurt you so badly is going to potentially have unsupervised visits with your child. Unfortunately, we're just in the legal system that we're in. And as lawyers, our job is to do the best job we can for you, but we're bound by the legal system and the laws of the state as well. So we're just going to try and get you the best result that we can legally and ethically.
Help your client understand her role and responsibilities, and explain the possible consequences if she fails to do her part.
And so what if we agree to this? As I told you, he never sees her. What if I just don't take her, right? I could probably do that.
Well, I understand your frustration about that and your concern about Sarita and his drinking and not being around her. But if the court orders you to visit with her, to take Sarita to the visits, and you don't do that, the court, will not like that. There are certain things that the court would find problematic about that. You could get into some trouble in that the court might hold you in contempt, and what that means is that the court could say that you deliberately didn't take her and you failed to obey an order.
Practice client-centered lawyering. While your role is to give information and make recommendations, the client should make the ultimate decisions in the case.
What if I just get rid of the order of protection? I feel like if I do that, all of this nonsense with the custody, will be dropped, and we can go back to him never being there, and I wouldn't be forced to see him or, have him see her. I don't know. I think I should. What should I do? I don't know. I want to drop the order of protection.
Okay. So we understand your concern about that. You think that if you drop it, then he will drop the custody case and leave you alone. When you asked for the order of protection, you described some of the things that he had done to you.
Mm-hmm.
So, it's really up to you to decide how safe you feel, and if you feel that an order of protection is necessary to actually keep him away from you. That's something that you have to make a personal choice about.
But what would you do? What would you do if you were me?
Yeah, it's hard. We really can't answer that question. This is something that you know him. You're the person that knows him better than anyone. And you know whether the order of protection is going to be useful to keep him away from you. So that's really a question that you have to think about. You don't have to make a decision now.
Mm-hmm.
We have a few weeks before our next court date, and you want to really think about that. If you fear for your safety, that's something that you might want to consider, whether dropping it might be something that signals to him to come to your home again, or to try and locate you in some other place.
Right.
If you remember from the retainer letter that we signed in the Statement of Client Rights and Responsibilities, we reminded you that all the decisions about this case have to be your decisions, because this is your life and you're the only one that can really know what you need and what your goals are.
Mm-hmm.
So as attorneys, we're happy to advise you, and we can tell you about potential consequences of one decision versus another, but at the end of the day, we're not going to tell you what to do, because you're the one that has to live with whatever outcome you decide to do. Does that make sense?
Yes. Mm-hmm. But what could be the consequences of dropping the order of protection?
So that's a really good question, and it's an important one too. It might signal to the court that you're not, that you didn't have any fear of him, and that you didn't need the order of protection.
Mm-hmm.
The other thing is that even if you drop the order of protection, it doesn't guarantee that he's going to drop the visitation case. As I said, you know him best, and that is really your personal choice, but it really doesn't guarantee that he's not going to continue to try and see Sarita.
Okay.
Make sure the client has your contact information before she leaves. Conclude the interview by reviewing what was discussed and the next steps.
So maybe for our next meeting, as I said, you can think about any friends or family members that you might have that would be available. We want you to contact us. If anything happens in between now and the court date, you have my number, you have Anna's number and information. When we next go to court, you're going to appear. You don't have to bring Sarita. You come yourself. If you have anyone, a friend or family that wants to accompany you, that's fine. If they're a witness, we usually would ask them not to be inside the courtroom. There's also a place called Safe Horizon. If you feel uncomfortable, if you've decided to go forward with the case and you feel uncomfortable and you don't want to be in the waiting area with him, we can wait in Safe Horizon and then bring you into the courtroom. But he will be there, and we'll have a conversation with him, or if he has an attorney, we'll have a conversation with an attorney about what he's actually looking for.
Okay.
Okay, but any questions, go ahead and give me or Wendy a call, all right?
Okay.
It was really nice to meet you.
It was nice to meet you too. Thank you.
Okay, good to meet you.
Thank you.
Keep in mind some important takeaways from this interview. Make sure the client is able to understand you. Avoid complicated legal language. Always validate the client's feelings and concerns. Keep the client involved in legal strategizing. Manage your client's expectations and never guarantee a particular result of a court case. Use client-centered lawyering to be sure that the decisions made are in keeping with the client's wishes. It is very common to be working with a client who is limited English proficient, or LEP. You may need to communicate with your client through an interpreter. Be assured that this method of communication can be extremely effective. By representing a client who is LEP, you are providing an essential service and meeting the needs of our increasingly diverse community. Here are some very basic tips, and there is more information in your manual. Instruct the interpreter to interpret exactly what you say. Interpreters should not paraphrase or summarize your statements. Introduce who is in the room, especially if over the phone, and give the interpreter a very short overview of the purpose of the interview before you begin. Remind both the client and interpreter that the conversation is confidential and privileged. Communicate with your client as if the interpreter was not there. Make eye contact with your client, not the interpreter. Do not use third-person pronouns such as she, but instead speak directly to your client using you. Speak at your natural pace, but speak in 1 or 2 sentences at a time so that the interpreter can effectively and accurately interpret what you are saying to the client. Try to avoid breaking up a thought so that the interpreter understands the meaning, not just the words, of what you're saying, but stay away from long streams of thought. Ask if your client understands what is being communicated and ask her to explain to you her understanding so that you can confirm that there are no issues getting lost in interpretation. If something is unclear or if the interpreter appears to be struggling, offer to rephrase and clarify. The interpreter may also ask for a repetition or clarification prior to their interpretation. Interpreters should not be providing their personal opinion or commentary on the information being conveyed. If the client states an understanding that is different from what you said or indicates that the interpreter has advised her in some way, you should address the interpreter directly to request that they stick to conveying the meaning of the source language and avoid interjecting their own opinion. Also, if it sounds like the interpreter and the client are having a back and forth conversation without you, they probably are. You should interject and ask that the interpreter relay the contents of the conversation to you and to stick to interpreting what you say. Allow the interpreter time to take notes, especially if you are providing details to the client, such as dates, numbers, or addresses. Understand that the interpreter needs time to digest the source language and interpret it into the client's native language. Interrupting the interpreter can derail his or her train of thought, throwing off the meaning that is being conveyed and cause confusion. When speaking to clients with or without an interpreter, keep language straightforward and avoid legal jargon. If there is a legal term that you need to use, explain it in terms understandable to your client. It is important to be aware of and understand the importance of your client's culture and how it informs her way of life, her values, and her thought processes. Culture is defined in many different ways and includes the attitudes and behavior characteristics of a particular social group, a social group that you may not be familiar with. You may not be familiar with the beliefs, social norms, and predominant attitudes of your client that are informed by her culture, religion, ethnicity, and/or socioeconomic background. However, acknowledging your unfamiliarity and gaining an understanding of an individual's cultural background is key to effective communication and relationship building. Be aware of your own attitude regarding cultural differences and maintain an open mind and willingness to learn. Culture influences the way individuals act and react. Understanding the context in which your client makes decisions and derives meaning out of events from a cultural perspective is crucial in being able to present her case effectively to the court. The motive behind certain behaviors may not be what you may naturally assume given your culture and personal experience. Don't be afraid to ask why questions, but avoid coming across as being judgmental. Preface your question with qualifying language such as, "I'm trying to understand why you decided to do what you did in order to present the best case possible for you. Can you tell me why?" Your client's culture may inform how she communicates with others, including body language, such as avoiding eye contact, or narration style. She may not provide information to you in a linear fashion. Communication can be linear, spiral, circular, or tangential. Practice effective interviewing by learning and adapting to your client's style of communication. Develop the capacity to focus on content rather than style. Practice active listening and understand who she is from a human perspective. What does she value? How does she perceive the world? What shapes her attitudes and beliefs? Develop an awareness of not only your client's worldview, but your own.